Almost everyone assumes that if you own a piece of land, you can gradually start living on it without anyone noticing. But that's exactly where people get caught out. It's rarely one big mistake that leads to enforcement. It's lots of small changes that slowly turn occasional visits into what the planning system sees as residential use. In this video, we'll look at how the process happens, why enforcement usually builds over time rather than arriving overnight, and why the 10-year rule doesn't protect people in the way they believe. So this is part 29 in the video series, and we're on chapter 3, living on the land or water, parking up and planning reality. And this is the second in a number of case studies which use the information we've already covered in this chapter. So, case study, land use without permission. A small parcel of agricultural land is used by a caravan. At first, the process is light. A few nights here and there, no permanent setup, no obvious structures, nothing that draws attention. In planning terms, this kind of use often sits below the threshold of immediate enforcement. It is not necessarily lawful, but it is not yet visible enough to trigger action. Under the Town and Country Planning Act 1990, the key issue is whether there has been a material change of use of the land. Agricultural land used for residential purposes, even intermittently, can fall into this category. But in practice, enforcement is not automatic. It depends on awareness, evidence and priority. Low impact, low visibility use can exist for some time without formal intervention. Over time, the pattern changes. The caravan is there more often. Visits become longer stays. Small additions appear, a water container, a generator, perhaps some fencing or storage. None of these taken alone seem significant, but together they begin to form a recognisable use. The land is no longer simply agricultural in character, it is being lived on. This is the point at which planning risk increases. The system does not respond only to what is done, but to how clearly it can be seen and evidenced. Once activity becomes visible, either physically from neighbouring land or through increased traffic, noise or presence, the likelihood of complaint rises, and complaints are one of the main triggers for enforcement action. When a complaint is made, the local planning authority has powers to investigate. If they consider that there has been a breach of planning control, they may issue an enforcement notice under Part 10 of the Town and Country Planning Act 1990. This notice will set out what they believe has occurred, typically an unauthorised change of use to residential occupation, and what steps must be taken to remedy it. In cases involving caravans, the Caravan Sites and Control of Development Act 1960 also becomes relevant. The stationing of a caravan for residential purposes can require both planning permission and a site licence. Less specific exemptions apply. Without these, continued occupation can be treated as unlawful. The notice will usually require the cessation of residential use and the removal of the caravan and associated items without a specified period. Failure to comply is a criminal offence. At this stage, the issue may no longer simply be planning compliance, but enforcement through the courts. Typical compliance periods vary depending on the local authority. The seriousness of the breach, the seriousness of the breach, whether people are living there full time, and whether there are environmental or neighbour complaints. In practice, for unauthorised residential caravan use on land, authorities often allow somewhere in the range of 28 days, where the authority wants rapid cessation, especially following complaints or obvious permanent occupation. 1 to 3 months, quite common for straightforward cessation of residential use and removal of caravans, generators, fencing, waste and associated domestic items. 6 months or more, sometimes granted where the occupier is cooperating, has welfare issues, children involved, or where substantial clearance works are needed. When an enforcement notice is appealed, the process can extend far beyond the original compliance period, often many months or even years before final resolution. Once the notice takes effect, however, failure to comply within the stated period becomes a criminal offence under the planning legislation. Authorities may then prosecute in a magistrates' court, seeking injunctions or in some cases carry out direct action themselves and recover costs. It's also worth noting that authorities sometimes distinguish between ceasing residential occupation, removing caravans used for living, removing operational development or structures, and restoring the land to its previous condition. Each may have separate compliance deadlines within the same notice. What is important here is the shift from tolerated presence to enforced removal rarely hinges on a single moment. It is cumulative. Each additional element, longer stays, visible infrastructure, signs of habitation, adds weight to the case that the land is being used in a way that requires permission. There is also a time element, but it is often misunderstood. People sometimes assume that if they can remain on land for a certain number of years, the use becomes lawful. While there are time limits in planning law, such as the 10-year rule for change of use, these only apply if the use has been continuous and can be evidenced, and they offer no protection once enforcement action has begun within that period. Relying on time alone is a risky strategy. Evidence in these cases is usually about proving that a particular use, for example residential occupation of land or by caravans, has been continuous, substantial and uninterrupted over the relevant period. Local authorities, inspectors and courts generally look for a pattern of ordinary day-to-day living rather than isolated visits or temporary stays. Typical forms of evidence can include, there's quite a few here, utility records, electricity, water, gas or broadband usage, council tax demands or correspondence, electoral roll registration, driving licence or bank statements showing the address, GP, dentist or school records linked to the site, dated photographs and videos, satellite imagery or aerial photographs, delivery records and invoices, sworn statements or statutory declarations from neighbours or visitors, vehicle records showing regular presence, waste collection evidence, insurance documents, tenancy or land agreements, logs, diaries or calendars, and social media posts with dates and locations. For caravans and mobile homes, authorities often look specifically for indicators of permanent residential occupation, such as sleeping arrangements, cooking and washing facilities, post being received there. Children travelling to school from the site, regular overnight occupation, domestic storage, gardens, sheds or fencing, and generators, solar systems or septic tank arrangements. Historical satellite and aerial imagery can sometimes be used to support an evidence in planning cases, including imagery from sources such as Google Earth Pro, Bing Maps and historical aerial photograph archives. In practice, people often use dated Google Earth historical imagery, screenshots showing caravans, tracks, structures or gardens over time, aerial photos showing gradual development or continuous occupation, comparisons between different years, and metadata and time-stamped image captures. Google Earth Pro is particularly useful because it includes a historical imagery timeline, allowing users to view older satellite captures of many locations. However, there are important limitations. Satellite coverage may only appear every few months or years. Image dates are not continuous proof of occupation. Trees, shadows or weather can obscure features. A caravan being visible does not automatically prove residential use, and screenshots alone are rarely enough without supporting evidence. Authorities and inspectors usually treat satellite imagery as corroborative evidence rather than definitive proof. It becomes much stronger when combined with other material such as utility bills, witness statements, photographs, delivery records or council correspondence. In some appeals and certificate applications, applicants also use historic ordnance survey mapping, land registry records, commercial aerial photography, drone photographs, archive planning files and street view history where available. The key issue is usually not merely whether a caravan existed on the land, but whether continuous residential use can be demonstrated over the relevant period. Continuity matters. Long gaps where the land was unused, abandoned or reverted to non-residential use can break the period. Evidence also needs to be credible and reasonably consistent. Contradictory claims, for example, telling insurers one address and the council another, can seriously weaken a case. Importantly, once a formal enforcement notice is issued within the relevant immunity period, the clock is effectively stopped. Simply remaining on the land after that point does not continue accruing lawful time towards immunity. A common belief is that there is a 4-year rule for houses and 10-year rule for caravans. This is only partly true. The law does not distinguish between houses and caravans in that way. Instead, it distinguishes between types of breach. Building a house or using a building as a dwelling may fall under a 4-year limit, while using land for residential purposes, which is what most caravan situations involve, usually falls under a 10-year limit. In both cases, the use must be continuous and proven, and any enforcement action within that period prevents the use becoming lawful. Time alone does not create permission. For those living off-grid or moving between sites, this creates a tension. A low-impact presence may pass without issue, but as soon as it begins to look like settlement, it enters a different legal category. The system is less concerned with intention and more concerned with observable use. In the end, enforcement does not arrive out of nowhere. It builds in response to what becomes visible, provable and contestable. What began as occasional use of land becomes, step by step, something the planning system recognises as residential occupation, and once it is recognised, it is regulated. So, what's the real lesson here? Planning enforcement is usually about patterns rather than single events. Every longer stay, every extra structure and every visible sign of everyday living adds to the overall picture. If you're trying to live differently, this isn't just about owning land. It's about understanding how the planning system recognises residential use before you accidentally create it. In the next video, we'll look at another situation where appearances can be deceptive and why understanding the legal framework before you act can save years of difficulty. So we're still in Chapter 3, living on the land or water, parking up, planning reality, and we're going to do another case study on gradual agricultural establishment.